My lord,
Yes.
item number 13.
Yes.
I need a week time, my lord. I pray for a week time, my lord.
No objection, Lordship. In fact, this matter was heard at length by your Lordship.
Yes.
There are many matters which are hard.
Subsequently, my lord, some documents were provided to me.
The
So
citation
I'll
judgment,
understand.
Lordship.
That part. Even me, I have to provide you, my lord.
That will be next week, Lordship.
The request made on behalf of the state respondent and not objected to the learned counsel referring to the appellant. This is matter after 1 week.
After a week.
After 1 week.
May please Lordship. May please Lordship, item number 1718, Lordship, I wish to mention.
Yes.
This matter may come up after 3 weeks because the petitioner they are getting interim
Here
order.
for the respondent.
Yes, for the
There
respondent.
is interim order in favor.
Yes, is there favor?
Sorry,
Okay. Any objection?
petitioner, no objections.
Lordship.
Mr. Sulai.
No.
Yes, the request made by Mr. Mr. Jamal learned counsel referring to the respondent number so and so. This is matter after 3 weeks.
Lordship.
17-18. Good.
Similar prayer for item number 25, my lord. Here I brought a petitioner. I think one of my colleagues is absent here. Requested me also.
Who is the other side?
Actually, Mr. Sheikh was appearing from the government side on the last occasion.
No. There is no. I'm there also. No objection. No objection. 25. The request of the petitioner. List
After 3 weeks.
after 3 weeks. Yes.
Lordship.
So, Lordship, I beg to make a mention of item number 10. If this matter may be taken up after 2 weeks, Your Lordship. Item number 10.
Yes. Be loud so you can.
Item number 10, Your Lordship.
Yes.
If
What
this
do you
matter
want?
may be taken up after 2 weeks, Your Lordship.
Yes.
No objection, Your Lordship.
This district council is there. Yes. No objection. No. This also the request made on behalf of the petitioner and not objected to with the learned counsel response. Yes, for 2 weeks.
2 weeks, Your Lordship. Your Lordship, item number 14 and 16, we were supposed to file our additional activity, Your Lordship. However, parties are unable to come, Your Lordship. If we can file
14 and 16.
Yes.
Additional affidavit is
Additional
required.
affidavit with regard to 161 statement, Your Lordship.
Yes. After?
This is such,
1
any,
week, Your Lordship.
any such order asking
Yes,
you
sir.
to file
Last order is there, Your Lordship.
in both the matters.
In
Three
all,
matters, all
three
three
matters are there, Your Lordship. Let come of the 2 weeks then, Your
Which
Lordship.
matters?
Item number
14, 15 and 16, Your Lordship.
16.
All 3 matters.
Yes, Your Lordship.
Okay. Yes, sir, the request made by MSP Vishwakarma, Learned Counsel appearing for the petitioners. Further, how much time?
1 week time, Your Lordship.
1 week time is granted to enable the petitioner to file the additional
Affidavit.
affidavit.
Apply.
Much obliged.
List accordingly. Yes.
May I please, Lordship, I beg to mention item number 20.
Yes, Mr. Upadhyay.
This is a quashing matter which is pending before the division bench. It will have a bearing on this case. So matter may come up after 4 weeks, Lordship.
And for the private respondents, Your Lordship.
These issues are dragging, is not taken up. There are quite number of matters which are pending.
Yes, Your Lordship.
Just at the request of the parties, list after 3 weeks. Yes.
Lordship. And item number 27, Lordship.
Yes.
On the joint
27.
request. Lordship.
27. Criminal.
Yes.
Criminal appeal. On the,
After 2 weeks, Lordship. After 2 weeks, it has been admitted.
At the request made by Mr. S.D. Upadhyay, Learned Legal Aid Counsel, appearing for the petitioner. This matter after 2 weeks. Yes, 2 weeks, Lordship. Much obliged.
Permission. Item 17 was just mentioned, Your Lordships. The only request is the interim orders is to be continued, Your Lordships. I'm appearing for the petitioner in this.
Some interim orders in those items 17, 18.
Yes, it's already mentioned, my lord.
It is mentioned already.
Yes,
but then-
already mentioned that interim order may be
Your
continued.
Lordship,
Been
interim
already stated.
orders to be continued was not mentioned.
Anyway, this
I just-
those matters, interim order, those 17, 18, this interim order passed earlier shall continue.
Lordship.
Please, Your Lordships. I'm deeply obliged.
Then
Please, Lordship. I beg
Great,
to mention item 21. 21, Lordship.
yes,
Lordship, I pray for 1 week's time, Lordship. The conducting council has some personal difficulty. No objection, Lordship.
after a week, at the request of the petitioner. Yes,
Your Lordship, I beg to mention item number 9. Kindly let this matter come after 2 weeks, Your Lordship.
see, this is another matter which is pending for nothing. If you, is there any use of keeping the matter pending? This is a school teacher, isn't it?
Lordship.
Your Lordship.
Any objection?
No objection.
Not at the request of the petitioner, not objected by the learned counsel of the respondents. This is a matter of weeks. Yes.
Merciless Lordship.
Maybe, please, Your Lordship. Your Lordship, I beg to mention item number 26. Your Lordship, I pray that the matter be taken up after 3 weeks' time, Your Lordship.
This is the other side. Yes.
No objection, Lordship.
No objection.
No, Lordship.
Okay, the request. State is a party. Yes.
State says limited role in Lordship. It's
Yes. That is the request made by learned counsel of appearing for so and so. That's one number sensor. This is matter after 3 weeks. Yes.
please, Your Lordship. Lordship, I beg to make a mention of item 11.
Yes.
Lordship, I'm for respondent 1 and 2, Your Lordship. I'm for respondent 1 and 2, Your Lordship.
No objection, Your Lordship.
I'm praying for 2 weeks accommodation, Your Lordship.
No objection, Your Lordship.
The request made. State has any role here? This is what the recruitment related issues. Your taming appointment. Matter is pending for 5 years. So by the time it is over, you will attain your age of retirement. Yes, sir, the request made on behalf of the respondent number 1 and 2 are not objected to by the learned counsel of the petitioner. This is a matter after 2 weeks.
2 weeks. Lordship, similar prayer for item 12, Your Lordship. And I'm for the petitioner, Your Lordship, this item.
No objection, man.
This is also respected to by the petitioner and not objected to by the learned counsel of the respondent. Okay. 2 weeks. Yes.
Supplementary cause list, item number 1.
Yes.
Lordship, this is an appeal impugning the judgment and order dated 13/3 of 2025, passed in session case number 60 of 2020. Lordship, the impugned judgment and order is at page 36 and etc.
Page 36.
Yes, Your Lordship, and etc. And the operative part is at page 113, paragraph 167.
Page 100 and
113, paragraph
130.
167.
130 or 113?
113, 113.
Para?
Para 167. I may be allowed to read also. While the charge under section 307 is found not proved beyond reasonable doubt by the prosecution, in this case due to lack of evidence, since the IO has failed to collect the medical report of the victim from negligence, where the victim was treated, operated, and implantation of steel plate besides the only medical evidence at Exhibit 8 proved by first attending Dr. PW8, only justify conviction of accused under section 325 IPC and not sufficient for convicting the accused under section 307, though the intention of the accused to hit at the head seems to be with knowledge that likely it can cause death, but with the stated injuries sustained by the victim as per Exhibit 8 proved by PW8 other than the dislocated jaw, which seems to be the only serious injury, but PW8 seems to have just examined the victim externally when she was immediately referred the victim to negligence, from where the IO has not procured the medical evidence to prove the intention under section 307 IPC when in this case the IO had also failed to recover the crime weapon and even the mens rea angle is not investigated by the IO. In the premises in this court, though hereby acquits the.
So you are charged under 307 and 325.
Yes, Your Lordship.
And the trial court found that no evidence for conviction
Yes,
under 307.
Yes, Your Lordship.
But then maintain conviction under 325.
Yes, Your Lordship. So I was
Yeah.
convicted only under section 325.
Yes.
And sentence order is at page 115, annexure 4.
We will admit the appeal. Notice. We will admit the appeal. Notice will be issued. How long? What is the sentence?
Sentence 3 years, Lordship. And fine of rupees 25,000.
Filed any application for suspension of sentence?
Yes, already, Lordship. The learned court has already suspended the sentence for a period of 1 month, Lordship.
And then?
So, Lordship, so accordingly, Lordship, I have filed a misapplication for suspension of the sentence, Lordship. And
Yes, sir. Had Mr. Beated. Learned counsel appearing for the appellant. Admit this appeal. Call for the records. Appellant admit this appeal. The yes, call for the admit this appeal. Mr. Guru. Learned GA. No change in designation.
No, my lord.
Learned GA. APS for the respondent. Then you say call for records. List this matter immediately after receipt of the trial court record. Anyway, come to your interim prayer then.
Yes.
Yes.
I filed a.
What do you say?
My lord has to see, my lord. I don't have to say, my lord. If there is anything gross or, my lord, apparent on the face of the, my lord, record, that has to, we have to go into the evidence, my lord, evidence part.
But then this conviction is only for 3 years.
That is there, my lord, bailable, of course, but, my lord, at the time of trial, he was accused of 325, but here it is a conviction. So there is no difference between the bailable and non-bailable offence at the time of, my lord, appeal for consideration of suspension of sentence, my lord. So, my lord, in a week time, my lord, we will have a hearing on this. He still has got the time of 1 month.
Lordship, in this regard, I may be allowed to place one decision of the Honorable Supreme Court.
I have plenty of decisions, my lord, whether.
You are on bail.
Yes,
Heard, Mr. B. In this miss case. Where is the miss case? Yeah, miss case 23. Criminal miss case 23. Okay, 25. Heard, Mr. B. Learned counsel. Applying for the applicant. And also Mr. Argurum. Learned counsel. Applying for the respondent. Stop. By this application, the applicant has paid for suspension of sentence. The judgment and sentence was passed on the same day.
Same day.
Yes. Paid for suspension of sentence dated 13/3/2025. Passed in session case number 60 of 2022, 60 of 2020, whereby the applicant was convicted under section 25 IPC and sentenced for a period of 3 years. Along with payment of fine, there was
Yes, sir.
25,000. 25,000.
25,000.
along with the payment of fine of rupees 25,000,
My lord.
and in default
1 month.
to undergo another 1 month simple
imprisonment.
Simple imprisonment. Next paragraph. The applicant was initially charged under section 307 and 325 IPC. And after the completion of the trial, the Malaya trial court did not find sufficient. After the completion of the trial, the appellant, has been convicted under section 25 IPC only, as the London trial court did not find sufficient evidence to convict the appellant under section 307 IPC. What is the maximum punishment for 325?
7. May extend to 7.
And the trial court has given you 3 years.
Yes.
The maximum punishment prescribed for an offence under section 325 IPC is 7 years. The London trial court, after taking into consideration all the relevant aspect, has decided to impose a sentence of 3 years only. Stop. It is stated by the London Council for the applicant. The applicant is on bail which was granted to him after his conviction and sentence by the trial court. Stop paragraph. Having considered the fact the applicant was initially charged under section 307 and 325 IPC and subsequently found guilty only under section 225. And that the that no maximum punishment has been, and that only 3 years imprisonment has been awarded to him for the offence under, for commission of the offence under section 325. Come on. This court, come on, this court deems it appropriate to suspend the order of sentence dated so and so, passed in connection with the session case number so and so by the so and so till the disposal of the connected criminal. And at least you have not raised that liberty will be misused. Yes, this misplaced and disposed.
Deprivilege.
Daily causeless. Item number 1.
Yes, Mr.
The report has come from the trial court. The report has come. I'm praying for a week's time, for some time for getting the authority in this regard. All the records has come.
There is a landlord. This is a landlord-tenant dispute.
Not exactly, my lord. The respondent had executed a sale deed in my favor, but they were not. They were still. She was still staying in my landed property, my lord.
You have come against concurrent finding.
My lord.
You will have a uphill task.
I can understand. That's why, my lord, I'm praying for some time to get some authority, my lord, in this regard, my lord.
Lordship.
The learned counsel, appearing for the petitioner, established that the relevant record of ejectments suit number 4 of 2022 and this case number 70 of 2012 has been received. And the matter is now ready for hearing. Okay. As paid for by the parties. This is matter after when?
Maybe get convenient a week or maybe 2 weeks.
Or maybe just 1 week also, Lordship, or 2.
Having holiday in between.
Discretion of the court, Lordship.
1 week has no money. After 2 weeks, which is a holiday in between till come the holiday. After just what is it? Yes. This is matter after 2 weeks for hearing. Yes.
Obliged.
Item number 2. Item number 3.
Yes.
Lord, the service on respondent number 4 and 5.
You are supposed to file an affidavit.
We are filing it in the course.
Your Lordship, I am appearing for respondent number 4 and 5, Your Lordship.
The office note dated 3/4/2025 indicates that an affidavit of service, an affidavit of service showing the effectum of service of notice upon the respondent number 4 and 5 has not been filed. So, however, MS so and so learned counsel, you are appearing for 4 and 5 both.
Yes, Your Lordship.
Learned counsel has entered appearance on behalf of the said respondent today. Stop. Since the appearance has already been made on behalf of the respondent number 4 and 5, the requirement of filing of service affidavit is dispensed with. Now, what is to be done now?
You can fix it for hearing next week, for the Your Lordship.
After a week, Your Lordship.
Why after a week? What is the urgency here?
There's no urgency, my lord.
Let it come after 2 weeks, my lord.
The only issue, my lord, the trial is still undergoing. That's the only issue. And the complainant, they reside somewhere in Assam. And if the notice is summoned, my lord, if they are summoned, they have to come all the way from Assam. Yeah.
That is a system everywhere. It is there.
Yes. We can have it after 2 weeks. My lord.
The accused want more comfortable trial. Just in the paragraph, the parties submit. The land council for the parties submit that matter is ready for hearing. Accordingly, this matter for hearing after 2 weeks. Yes, Oblet.
Item number 4.
Yes,
civil division, Lordship. I
Yes.
believe my learned friend is appearing.
Also, I'm entering appearance for respondent 1 and 2 on behalf of Mr. P.R. Paske. Lordship, I pray for some more time to see instruction and file our affidavit.
Yes. Okay, Mr. Swainsa, Learned Counsel, has entered appearance on behalf of the person number 1 and 2, and prayed for
3 weeks time, Lordship.
some time for taking necessary instruction. Stop. The prayer alert. You'll list this matter after 3 weeks.
Much obliged.
Item number 6.
Yes. Achha, who is respondent number 3?
My lord, I'm for respondent number 3.
Okay, what is to be done today?
My lord, I believe the matter is on maintainability. Since it has been filed by...
Plea was read by the state, not by you.
My lord. My lord, I'll also be...
You want to take advantage of that plea?
No, my lord. I just want to...
No, you also can take it.
I want to bring the law as it exists on it, because the persons who have filed this petition under 482, no, with the new code 438, my lord, they have no loci standi to file this petition at all. They are not associated with the case. A similar matter had come up, my lord, earlier, and the apex court had decided in it. I'll place the relevant citations also to the effect.
What is that?
May?
Ready for hearing on maintainability?
It will be another date.
Yes, sir. Mr. Khera, Learned Counsel has entered appearance on behalf of the respondent. See today, and has also raised the plea of maintainability of this petition.
My lord, my lord, if I may, my lord, this particular matter, there is a direction from my lord's court that the police has to investigate the matter expeditiously.
No, there is nothing, no such direction.
My lord, if I may, this matter can be taken up now, my lord.
No, is a direction by this court?
My lord.
In some other matter?
In this matter.
In this matter?
My lord.
There's only one order.
No, my lord, we had filed a criminal petition number 71 of 2024. I had filed that. While my FIR was not being registered, my lord, when I had filed it. There was so much of pressure. While deciding that matter, my lord.
That order is passed in some other case, not in this case.
My lord, this case.
Mr. Khera,
my lord, the
Khera,
FIR.
The matter is same, but then this is not the same criminal petition.
No,
Try
no.
to understand that.
My lord, it's a different criminal petition.
That is what. So order was passed in a different case, not in this
my
case.
lord, but in regard of the same
Subject
FIR.
matter, yes. So that is what you say.
My lord.
That is what you say.
My lord. My lord, page 2, last para.
Yes.
During the course of hearing, it is brought to the notice of this court by the learned counsel for the petitioner that that consequent to the filing of this application, a case has been registered by the Umiam Police Station, White Umiam PS case number 21 of 2025, under section 1091, 1173, 1262, 337, 313, so on. And court says, my lord, the police is expected to investigate the above case and complete it as early as possible.
Yes, it's all right. We have seen it. Yeah. We'll just give him one chance. Let him go through this and then come back to us.
My lord.
In this case, he was referring. We didn't have any knowledge about it.
It's all right. No problem. It's all right. Only thing is that you see, the Mr. Devnath, the issue here is simple. That whether you see, you can take over the matter at this stage or not. And apart from that, even if you take over, whether this investigation needs to be stopped, needs to be scuttled.
My lord, on that also the law is settled. When it says they can exercise their discretion under 125, the provision under which they have come, but it can only be done after the charge sheet has been filed, if any.
That is what. See, they can claim trial after the matter is charged.
My lord.
But then that is what the understanding. You see, that is the basis. Basically, initially this court was not at all inclined to enter in this case.
My lord.
But then, having realized the fact that there is a rule, and there are certain provision of rule which requires to be.
My lord, the law is well settled in Catena of Judgments, where the court has categorically said, my lord, the spirit of 125 by itself denotes that investigation by police, if it is not done, how can they come up to the court to take over the matter? The spirit of 125 itself says, only once the investigation is completed and a charge sheet has been filed, that is when they can come up. In fact, that is the time when the court, my lord, will issue a notice to the commanding officer of the person concerned, telling him that this case has come up if you wish to take it up. The law is settled on that. In this case, the petitioners, my lord, let them not, they don't even have any loci standi, they are not even the commanding officer of the accused in question. They cannot twist the matter to an extent.
It's all right.
In this matter, before hearing, I may be in a position to file some additional documents later.
This is criminal division, so it will be question of law. What documents? Nothing.
So here you look at this learned friend is saying that the state is coming after the charge is filed. So I
state is not coming after the charge sheet is filed. Here submission is something different.
No,
if you are ready for hearing, then we will proceed. That is one way. You see.
We are ready, my lord. If they are ready.
Are you ready?
Another day.
So that is what. Then you prepare yourself properly. Then you come. There is no question of making half-hearted submission. Yes. What? matter of division stuff. Mr. Devnath, CGC, please for grant of some time to enable him to prepare the matter. Prayer allowed. List is matter after a week. We'll have it after a week. Yes.
Obliged, my lord.
Hearing item number 7.
Yes. What is this matter about?
Your Lordship, as per the last order, respondent number 6 to 12 is supposed to seek some instruction.
Who are respondent number 6 to 12? Oh, there is a CMJ matter.
Yes.
Do you think he will be appearing anymore in this matter? When this university is not in existence.
In that case, in that group, the matter Lordship, the notice be issued to the CMG directly. Lordship.
No, but then CMG is not there. It is not in existence. We cannot issue any notice. To whom shall we?
It has been resolved. It has been resolved, but it's for them to take step.
No, that is for them. Yes, definitely for take these things. But then you see, until unless somebody appears, you do not know what is to be done. Now, it is for you to look into this matter, whether you will keep them as respondents or will strike them out on.
They are very much still required to be respondent. On the last occasion that Ticket Data has appeared before this honorable court, and he made a categorical statement that he will take an instruction with regard to change circumstances.
That's all right. That was probably his instruction on that day. Now, counsel may, you see, like, you may not have any further instruction to appear here. Why should he? He is a professional. Why should he appear? It is not his personal responsibility. He doesn't take it in. But it's not his personal case.
Lordship, this matter may be listed after 2 weeks, then we'll take appropriate instruction. Yes, Lordship.
Lordship, yes.
Yes. Yes. In terms of order dated, in terms of previous order dated 13/3/2025, stuff Mr. D.K. Datta, Learned Counsel, appearing for the respondent number 610, where supposed to take some fresh instruction. Stuff, however, the said counsel the said Learned Counsel is absent today. It is informed that the state council was representing the CMG University all this 6 to 10, these are all authorities of CMG.
Yes, Your Lordship.
All are
students of
this council. It is informed that the Learned Council was representing respondent number 6. The respondent number just not say this thing. It is informed that the respondent number 6 to 10 are authorities of East 12 CMG University. Which now stands dissolved by virtue of an order passed by the state authority, state government. Stop. As the university, as the CMG University is not in existence, as it appears, CMG University is not in existence now. The Learned Counsel for the petitioner shall take appropriate instruction as to whether this matter still needs to proceed against the said respondent number 6 to 10 or not. What? Okay. The necessary instruction may be taken within a period of 2 weeks.
Lordship.
Please there.
8 also the same order will follow, yes. 7 and 8.
Same order.
Same order, yes.
Same respondent.
Same respondent, yes.
So earlier order also was like that.
Yes, Lord.
Yes. Same order.
Hello, Blake.
Item number 19.
Yes, ma'am.
Wait, is your lordship's learned senior counsel is on legs before courtroom number 2.
Now this has become a problem, real problem.
We can wait for some time if they are interested to take up.
Lordship will have that matter at the end of board. End of board, lordship.
End of the board. You are sure it will be taken up today? Otherwise, you will not make senior counsel wait here. And if you make him wait here, then make sure that matter is taken up.
Lordship after 2 weeks.
Now that is what the problem is. You should come with a definite instruction. What is this matter about, Mr. Chakraborty?
It arises out of a CBI case. The matter was argued at the stage of consideration of charges, and the accused were discharged.
Achha, you were accused. You were the accused.
They have
you
come
are also
again.
there. So now they have challenged that order.
They have challenged that. We are ready whenever it's convenient.
And even grant of adjournment also will not have him. Yes, just at the request of Mr. Ms. Nogra, learned counsel appearing on behalf of DSGI. This is matter after 2 weeks. Yes.
Obliged.
Item number 22.
Yes.
Madam, I am the landlord here. Degree of eviction was passed by the learned district judgment against the respondent. My lord, it was passed on 2nd May 2024.
One of you can go.
By the learned degree of eviction was passed by the learned district judge on appeal. My lord,
you are.
I'm the landlord.
Oh, you are the landlord.
Yes.
Okay. So you filed a suit for eviction.
Yes.
You got the degree.
My
Yes.
lord, at the first instance, I lost the degree. Suit was dismissed. Then I filed an appeal, and degree of eviction was passed.
Okay. So appellate degree.
Appellate degree.
You hold appellate degree.
Yes, my lord. Yes. My lord, when the degree was passed, my lord, thereafter, after 2 months, I filed an execution proceeding before the court. My lord, execution proceeding.
This order appellate degree was not challenged.
No,
any
my lord.
further. Yes.
I will come to that. Thereafter, my lord, I filed an application for execution of the degree. And my lord, white order dated 9/7, page number 22, my lord.
Page number 20.
22.
There is no pagination here. Your petition, there is no.
Except.
Oh, achha, yes. Answer 22. Yes, page 22 is the order. Yes.
Yes, madam. The learned executing court was pleased to direct the bailiff to execute the degree.
This order dated 9/7/2024.
Yes, my lord. The executing court passed the order for execution of the degree, directing the bailiff to execute the degree.
If you hold take steps or prepare a notice to bailiff accordingly.
Yes, because it was before within 2 years.
Yes.
So, my lord, this order was passed, and my lord, before the degree could be executed by the bailiff, the respondent filed one application, my lord, for staying the
execution proceeding.
Where the suspended was issued notice?
My lord, notice was not issued because the degree was
within 2 years.
Yeah, within 2 years. So why?
Anyway, so they came to know it and they filed an application under.
Yes.
Yes. Order
My lord,
21.
then they filed an application. That is page number 23.
Yes.
This application was filed by the respondent under Order 21, Rule 26.
Yes.
And the page number 23, my lord, and the ground it's mentioned in page number 24. Page number 24, my lord. This is a 3-paragraph petition.
Yes.
The paragraph says that the petitioner has filed a review application on 18/6/2024, wide review petition number such and such against the interim judgment and order of the district judge in PCA number such and such, and the matter is fixed for hearing on 30th August.
Yes.
The degree holder duly received a copy of the review application and has also entered appearance on 8/7.
That means you.
Yes, ma'am. And as such, fully aware and conversant with the latest development, but in spite of that, by suppression of material fact, persuaded the court to pass an order of execution which is required to be stayed immediately. So this application was filed under Order 21, Rule 26. So, my lord, I can take your lordship to the Order 21, Rule 26.
Speaks of ground of stay
Yes,
of
my lord,
execution.
yes.
Order 20.
Order 21, Rule 26.
Order 21 is very lengthy, Mr.
Yes, my lord. Order 26. Order
21 Rule 26. Yes. Yes.
It says when court may stay execution. The court to which a degree has been sent for execution shall, upon sufficient cause being shown, stay the execution of such degree for reasonable time, to enable the judgment debtor to apply to the court by which the degree was passed, or to any court having appellate jurisdiction in respect of the degree or the execution thereof, for an order to stay execution, or for any other order relating to the degree or execution which might have been made by such court of first instance or appellate court, if execution had been issued thereof, or if the application for execution has been made thereof. So there has to be sufficient ground, and to enable the judgment debtor to apply to the court to which the court which has passed the degree, or to the appellate court. On these three grounds, my lord, stay can be granted for a limited period, for a reasonable time. And at the time of stay also, my lord, Rule 326, sub-rule 3 says, power to require security. Even if it is for limited period, my lord, then there has to be some
security.
Security.
This is okay.
So, my lord, now I'll take your lord.
Just a minute. Just a minute. Yes.
Yes, my lord. It says that power to require security from or impose condition upon judgment debtor. This before making an order to stay execution, or for the restitution of property or the discharge of the judgment debtor,
the court shall require such security from or impose such condition upon the judgment debtor as it thinks fit. So certain condition has to be imposed, my lord, and security, so that the judgment degree holder may not suffer. So, my lord, I will take your lordship to the impugned judgment. It is in page 27.
You have come against the order of the executing court.
Yes, yes.
By which the execution was stayed.
Stay.
On the basis of the application filed by them.
Yes, my lord. My lord, same court has passed the order and same court stay the execution order.
Yes. Oh.
Page number 27.
Yes.
My lord, it is on 29/7/2024. The court put up on call today. Date was fixed, your lordship, another date, but in the midst of the application, when they filed the application without my knowledge and without serving copy also, this order was passed. So, the court put up today on call.
This copy of this application was not served on you.
No, my lord. Date was fixed. Report for from the bailiff. It was fixed here, my lord. Another date was fixed.
See, you have referred to the order of 9/7, isn't it?
9/7 was the order for execution.
Yes, and then
29/7.
15/7 was for steps by
Yes,
DPO.
I have taken steps.
Okay.
And then I have.
And then when this application was filed?
This review application, my lord,
Yes.
it was filed on.
No, this application before the executing court
Was filed on 29.
Where is the date? Sure, there is no.
There is no date, but in the affidavit that is mentioned, and in the order also it is mentioned.
The affidavit, it is on the date of affidavit. Anyway.
Yes. But my lord, the order is clear, 29/7/2025. So it says record put up on call today. Petition under order 21 rule 26 for stay of the execution order passed by this court on 9/7/2024 is filed today. That is on 29.
Yes.
The averments in the petition are as follows. The petitioner has filed a review application on 18/6/24 by review petition number 1H of 2024 against the impugned judgment and order of the district judge in TCA number 1H of 2021, and the matter is fixed for hearing on 30/8/2024. The degree holder duly received the copy of review application and also entered appearance on 8/7/2024, and as such fully aware and conversant with the latest development, but in spite of that, by suppression of material fact, persuaded this court to pass an order of execution which is required to be stay immediately. Said petition is moved by Sri such and such advocate, who submits as per averments in the petition, and also verbatimly praised for allowing the prayer in the said petition on the ground that execution application before this court has been filed by concealing and misleading facts which led to the passing of order dated such as 9/7/24 and 15/7/24 by this court. Learned counsel submit that the degree in favor of degree holder in PCA number 1H of 2021 was passed by learned TSJ Shillong in appeal, and no endorsement is made to this court for execution of the same. Hence, learned counsel submit that the learned counsel for degree holder has suppressed fact as averred in para number 1 and 2 of the instant petition. Learned counsel thus submit that they will be directed not to execute the degree till further order, as injury would be caused to the petitioner judgment debtor herein, and in view of urgency of the matter, copy of the order of stay of execution be supplied to the petitioner herein today itself. Said petition being filed today is duly supported with an affidavit along with copy to the opposite party degree holder, and steps to be taken for furnishing the same to the opposite party in due course. Having heard learned counsel and considering that the matter review application against the impugned judgment and order of district judge is pending hearing on 30/8/2024, this court, on careful consideration of the fact and circumstances, on being satisfied of the urgency of the matter, is of opinion to allow the prayer in the instant petition number such and such.
execution proceeding in terms of order dated 9/7/24 and 15/7/24 by this court are hereby stay at this stage until further order. Let notice of a stay of execution proceeding at this stage be given to opposite party degree holder. Petitioner to take step. So, my lord, none of the grounds which is prescribed under section 20, order 21, rule 26 has been considered.
Why?
Because, my lord, order 21 says that the executing court can give reasonable time to the judgment debtor to apply to the court to which has passed the degree or an appeal. But here they have already filed. They are saying that they have already filed, and even prayer was made before the London Appellate Court to stay the execution. It was not considered. And then,
where is that order passed by the land?
No, there is no order of stay. That's why there is no order at all for stay of the execution. Only notice. And that also it was passed. It has been filed. That is separate issue, my lord.
No, the review application which was filed.
Yes, my lord.
What happened to that?
It is pending.
There is no order passed.
There is no order of stay. Only notice was issued, and they are taking time for hearing. No hearing has been done till then. Your Honor, if they are at all interested, they could have secured a stay order from the appellate court. They fail from the appellate court, then they came to the executing court. So the remedy which is available, they have already exhausted.
Yes.
So only
So
on
until
this
unless an order is passed,
Yes, my lord.
either by the court which passed the decree or by the appellate authority,
Yes, my lord.
it is not for the executing court
Yes,
to
my
stay,
lord. Yes, my lord.
isn't it? And so far as the section 26 which enables the executing court to stay it for a brief period,
Yes, my lord.
that is only for the purpose of enabling them
Yes, my lord.
to approach it.
Yes.
So that is what.
That is the only thing.
So having done that and having failed to obtain anything,
Yes,
orders is this. But then have you raised that plea before the executing court? So far as the executing court is concerned,
Yes, my lord.
the order of stay of execution is not a final order.
No, not a final.
So have you approached the executing court?
I have every time
by
I approach.
taking the ground that the court where the review application is pending has not given any stay. Have you brought it to the knowledge of that court?
I have brought it to the knowledge, but I have also
See, Mr. Pandit, one thing is that to give a finding that the impugn order is wrong is one thing, and to say the continuation of stay is illegal is another thing. Two different aspects. So far as this order is concerned, initially staying in their favor, doesn't seem to be that illegal, only except to the fact that they had already preferred the review application and the court had passed the order late.
Yes.
But then once the fact that no interim order was passed by the review court is brought to him, if thereafter he had continued the stay, then it would have become illegal.
My lord, in
But
that
then
application
where is
only
that
they
evidence
have-
that you have done it?
Had there been any stay, they would have. There is no occasion for them to again apply for the executive court. They have already mentioned in the petition that only
No, that
pending.
is, we understand.
Yes.
But then where is the thing that you have approached the executing court with that?
My lord, that order itself is beyond jurisdiction, my lord, because there is no power of the, that is the only
Yes,
thing.
yes, Mr. Singh.
Yes.
My lord, first of all, my lord, the review petition, the revision petitions which has been filed against the order dated 29/7/2024. This petition itself is not maintainable because, my lord, this is an interlocutory order, my lord. Against this interlocutory order, my lord, revision will not lie, and their remedy lies before the executing court, my lord.
Yes, what about interlocutory order?
My lord, interlocutory order, my lord, here this is filed under 115 and 227.
It's a revision petition.
So, my lord, the executing court has
Can
exercised
115 and
jurisdiction beyond.
227 can be invoked at the same time?
No, my lord.
You are making the thing more complicated now. The more you enter into, more you get entangled with those kind of agreement, then there will be more queries by the court.
Yes, I'll just read, my lord, this 115. 115, section 115, what it says.
We approach the executing court.
My lord, that order, my lord, if your lordship will see that order, that matter, the London court has satisfied only on the ground that since review application is filed, she cannot proceed. So even if I will approach the same, I can.
No. We cannot receive. Probably this order 21 rule 26 was not known to the court. It was not placed before the court. You place it before the court and get this order vacated.
My lord, since this.
What happened on 38? 38 is on 24.
Even, my lord.
Other orders.
Yes, my lord. I have also.
What is the difficulty for you in approaching the same court?
Yes, my lord. Difficulty is that, my lord, when the order is not has been passed beyond jurisdiction, my lord, then I have this honorable court, my lord. This honorable court has ample power to.
Beyond jurisdiction.
Again, if I will approach the same court, my lord.
See. The thing is that it is for you to inform the court that time can only be granted for availing the party to file
I
an
have
application.
approaching, my lord, that even this matter is pending before this honorable court. I am saying that there is no stay. The executive court is saying that since this matter is pending, I cannot proceed.
Where is the evidence that you approach the executing court? Or otherwise, just tell us how do you overcome that hurdle of interlocutory order?
I'll just.
Yes, please.
115, my lord.
Please.
Revision. 115. The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears, this interlocutory in civil matter, your lordship. Even this honorable court, unlike criminal proceeding, interlocutory.
No, you just read complete the reading.
The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of suit or other proceeding, except where the order, if it has been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding thereto. The High Court shall not, under this section, vary or reverse any order or order against which an appeal lies there, either to the High Court or to any other court subordinate thereto. A revision shall not operate as stay of the suit or other proceeding before the court, except where such suit or other proceeding is stayed by the High Court. So, my lord, only the ground is that if there is no provision for appeal or against the order which I cannot come for appeal, I can file an application for revision under 115.
So you say there is no other restriction.
There is no other restriction. Only if there is a remedy for appeal, then only revision is barred. Otherwise, this honorable court has ample power to interfere with the order if the same is passed beyond jurisdiction.
What about proviso to the
Provided that the
one?
High Court shall not, under this section, vary or reverse any order made or any order deciding an issue, if it is final, in the course of suit or other proceeding, except where the order, if it has been made in favor of the party applying for revision. It has been not in my favor.
No.
Would have finally disposed of.
Only those cases where it has been finally disposed of.
Finally
only
disposed of. This is not final.
And therefore it is interlocutory order.
That is interlocutory order. I can always come.
Against interlocutory order, revision is not maintainable.
No. In criminal cases, it is not maintainable.
No,
but
no,
interlocutory, in revision, only this honorable court, my lord 115, in civil cases can interfere with the interlocutory order. Otherwise, I will be remediless.
If I can read the proviso, my lord.
Yes, please.
Yes. It says, my lord, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding. Only in cases where the matter has been finally decided.
In his favor of the.
Yes.
So definitely. So if it was decided in his favor, this would have disposed of.
My lord, what?
So that way, that gives more.
Yes. No, my lord, here it says, provided that High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision.
He is the party.
Yes, he is the party, my lord. In favor of the party applying for revision, would have finally disposed of the suit or other proceeding in favor of him, my lord.
Yes.
If it had been decided.
So had there been the order was in his
Finally.
favor, that would have disposed of the execution of proceeding.
No, my lord, what it says is, it is reverse, my lord. Except where the order, if it had been made in favor of the party applying for revision. Here, my lord, revision has been filed
by me.
By the.
No, if it had been made. No, that is where.
Yes. If
So,
it had been made in favor of the party.
The order is not actually made in his favor. But then if it was in his favor, then this will dispose of the proceeding. So the plea of maintainability which you are taking apparently is not very clear. Yes,
My
any
lord,
other thing?
My lord, this proviso itself, my lord, this has to be read again and again, my lord. It is because it says except where the order. Now, if we see later portion, my lord, would have finally disposed of the suit. Now, here the order 29/7/2024, my lord, the impugn order which is under challenge. This is not an order which has disposed of the matter.
Disposing in his favor. The question, the matter doesn't remain confined only to the disposal. Disposal in his favor. What you say, it may be interlocutory in certain stages, in certain situations. But then here, if the order was made in his favor, that would have disposed of the matter in his favor. So that is what is requirement here.
My lord, my understanding of this proviso, my lord, is that the revision petitioner, if they file their revision applications, my lord, which they file, if they are challenging an order and the order is in their favor, what it says, my lord, where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or the protest. Here, my lord, the order, my lord, which is under challenge, this is an interlocutory order, my lord. This has simply stayed the execution proceeding. As far as main execution proceeding is concerned, my lord, that is still pending. And therefore, my lord, this order is an interlocutory order, my lord. It is an interim order.
You see, so far you were concerned, it may be interlocutory order.
Right.
But then so far he is concerned, in as well as the proviso is thing, he has a right to do it. Because if this order was in his favor, if this order was in his favor, then it would have disposed of this entire executive proceeding. Only thing is that where is a question of passing this order in your favor? See, the thing is you have not approached the executing court.
Yes.
Because you may do so, and then if the executing court does not pass any order in your favor, then only you can.
My lord,
when you say that yes, if this order was in my favor, this would have disposed of.
Yes. Had there been, your lordship, that for limited period the stay was there, then I would have not come. But it is says that
No,
until
that
further
is, that
order.
is you give
until
a
further order.
justify in law. See, it is
Yes,
not
sir.
a factual things. See, what it means disposal. Say supposing, take it vice versa. Say like, if this application was rejected, that would not have amounted to disposal of the matter.
No, no.
Then only thing is that the court would have proceeded
Yes.
to go ahead with the execution.
Yes, yes. And I would
But
not
then
have spent this
execution
much.
proceeding when it is disposed of.
Yes.
Execution proceeding when it stands disposed of. At what stage?
When the execution is complete.
Complete. So that is what. So even the rejection of this application would not have resulted in disposal of the matter.
No, 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 madam. I have come.
So in that way, that is correct. Is interlocutory order, no revision.
Interlocutory order, my lord. But this order, I am against this order. This order, your lordship, is contrary to the provision of law, which I have referred.
My lord,
you
that is the only thing, only my grievance. Otherwise, my lord, I am still entitled to again agitate
when
before the
there is
executing
lack of
court. There is
jurisdiction,
no
my
bar.
lord, court cannot enter into merit. There is a Supreme Court judgment.
Definitely, there is no question of going to merit.
No, not merit.
Only
On law.
thing is that
only on law.
it has to be brought to the knowledge of the court that there is no stay order passed by the review court, and then there is no bar for proceeding.
My lord, then this petition may be disposed of, my lord. Then let the parties, after hearing the parties, executing court pass not necessary order. This order, your lordship, I have
No,
challenged.
that is
this.
what that has to be.
Yes.
That way.
My lord, this application I have filed because this order was passed ignoring the provision of law. That because there was no justification, remedy has already been exhausted. Still, it was passed. Only my grievance was that. Otherwise, I would. Your lordship is also correct that I would have gone to the same court and I would have applied.
No, you should have exhausted that remedy.
But my lord, that
even if
yes,
even if the trial court had overlooked certain provision of law,
yes,
you could have approached the same court. There was no bar for you.
Yes, yes, there is no bar. But
Unnecessary,
I can
you see, like
come here also, my lord.
Instead of giving him a chance to argue the matter in a different way.
Yes, my lord. And the thing is that I have already spent 6 months here before this honorable court. I did.
But then that
so,
is you approach the court at your risk.
My lord, then this petition may be disposed of. Let the executing court complete, proceed with the execution proceeding and complete at the earliest. That is the limited prayer.
He can always go to the executing court, my lord, with any
No, I
applications.
have right. That is
against this order.
Administrator, can you take the order? Administrator responded, Learned Counsel, with the petitioner, and also Mr. Sinkan, Learned Counsel appearing for the. There is only one respondent.
My lord, there are three respondents, my lord.
They are all related, mother and two sons.
You will appear for all the respondents.
Applying, I'm only for respondent number 1, my lord. Others
My
they are
lord,
not contesting.
one respondent has already come vacated the
Others have been
premises.
served?
Yes.
Okay.
Already.
And also heard Mr. N. Sinkan, London Council appearing for the respondent number 1.
Yes.
And one is not appearing.
Okay. None. Then after full stop, you say none. None appeared for the respondent number 2 and 3, despite service of notice upon them. Sit down, please. This revision application, after paragraph, huh? This revision application has been filed by the petitioner, assailing the order dated 29/7/2024, passed by the learned Assistant District Judge Shillong in title execution case number 1 within bracket capital H of 2024. By which the proceeding of the execution case was stayed until further orders. Stop. Paragraph. The fact of the case is that the petitioner as landlord has instituted an eviction suit, E capital, okay, as capital, the court of the learned Assistant Judge Shillong. Which was registered as, within bracket you write eviction, then you write title suit number 35H of 2014 against the predecessor in interest of the respondents. Stop. The said suit was dismissed by the trial court by judgment dated 24/11/2021. How come there will be decree on this thing dismissal?
Because degree was prepared.
How can decree be prepared in a dismissed matter?
It was prepared, my lord.
How can it be?
No, the suit was even the dismissal of suit degree has to be there.
Okay, decree has to be there.
Yes, yes.
So that also, okay.
That has to be there.
So if you then that will be a decree in favor of whom?
Against favor of this respondent.
Can there be a decree in favor of the defendant in a title suit?
Dismissal of, there is always, my lord, there is the city's provision is there that dismissal of suit also there has to be a degree.
What is the provision?
Degree has to be prepared even if the suit is dismissed.
Anyway, it's okay. Anyway, leave it that. Okay, which are dismissed, isn't it? By judgment date 24/2021. Full stop. The petitioner
preferred an appeal before the London District Judge Shillong against the said dismissal. And the London District Judge allowed the appeal. And decreed the suit in favor of the petitioner, but judgment and decree dated 2/5/2024 for eviction of the respondents from the suit premises. Thereafter, the petitioner filed When did you file your execution case?
On 8/7/2020.
Okay. Okay.
Paragraph number.
Yes, yes. Thereafter, on the refusal of the respondents to vacate the suit premises, thereafter on the petitioner filed the title execution case number 1 of 2024 on 8/7/2024, seeking execution of the appellate decree dated 2/5/2024. Step. The London Executing Court by order dated 9/7/2024 allowed the prayer of the petitioner for execution of the decree. Fixing 15/7/2024 for steps by the petitioner. However, the respondent herein filed Do not say however, just cancel it. Just write this thing. Just cancel that line. Just after full stop you write, you say on 29/7/2024 the respondent herein. Respondent number 1. It was respondent number 1, isn't it?
One of the respondents.
Respondent number. Only respondent number 1 or one of the respondents?
One of the respondents, that is respondent number 2, my lord. Arif Ali, respondent number 2.
Jahida.
Arif Ali, 20.
Jahida Begum.
No, no.
Jahida Begum has filed.
No, no, Arif Ali, number 2, for a stay. Arif Ali.
No, see the application, page 23 you come. Come to page 23 of your petition.
This is, name is here, rather, represented by Zahida Begum.
Yes.
But others, but this application was filed by only affidavit, my lord. Only one respondent.
See Arif Ali.
Yes, yes.
That is okay, but then why the name is?
They have just given like that. Application was filed on only one place.
What is it? Just last one. One of the respondents here. Or you can say it is a respondent number 2.
Yes, my lord. Respondent number 2.
You say respondent, not so one of the respondents. You said the respondent number 2. Here. Filed a petition under CPC for stay of the order of execution, for stay of the execution, on the ground that the petitioner, that on the ground that the respondent had filed a review application on 18/6/2024 by review petition number 1H of 2024 in TCA T capital C capital number 1H of 2021. I think this number should have been given perfect before also. When he said that they filed an appeal, appellate court passed a decree. There that number, maybe this number we have not mentioned. The TCA number 1H. We just keep the thing note. We may later enter. Stop. The London Executive Court wide order dated 29/7/2024 allowed the prayer of stay of execution proceeding until further orders. Stop. Being aggrieved, the petitioner has approached this court by present revision application. Stop. Paragraph. Mr. Pandit, the learned counsel for the petitioner has assigned the impugned order dated 29/7/2024 on the ground that the order is apparently illegal as the learned trial court had no authority to pass such had wrongly passed the order just tell us what you say, Mr. So-and-so. Just has said the order so-and-so and submitted the passing of the impugned order is totally illegal and arbitrary, in as much as the learned court, in the learned executing court, has not taken into consideration the provision of Order 21, Rule 26, CPC, while passing the order, while passing the impugned order. Stop. He submits that an executing court can stay execution only on limited ground, where a judgment debtor limited ground to enable a judgment debtor to apply to the court by which the decree was passed, or to any court having appellant jurisdiction in respect of the decree or the execution thereof, comma, for an order to stay the execution, or for any other order relating to the decree or execution which might have been made by such court of first instance or appellate court, if execution had been issued thereby, or if application for execution had been made there. Stop. He submits that the aforesaid situation was not in existence while the application for stay of execution was filed by the respondent number 2, as the respondent number 2 by then had already approached the court by which the decree was passed. Seeking review he further submits that no order for stay of execution was passed in the review applications, and in such a situation the impending order cannot be sustained in law. Paragraph. You say on the other hand, Mr. Simpan Learned Counsel appearing for the respondent number 1. But then one thing is that you have not filed any application for seeking stay of execution. This is respondent number 2.
In the review.
And you are not appearing for respondent number 2.
My lord, I'm appearing for respondent
This should
number
have been
1.
pointed out because see, this is unnecessary things. Then
My
in
lord,
such a case, we can simply say that he has not filed any application.
My lord, we are appearing in the representative capacity, my lord, because they are mother and son.
You said already that you are appearing only for respondent number 1.
A previous order
You
is
cannot
also
now
there before this court.
turn back and say something different.
My lord, Vakalarnama has been filed only for one respondent.
So that is so then you have nothing. You have not filed any execution. This stay for execution.
But my lord, we
No,
have
no, then we
been
get
made
this
a
order.
party in this case, my lord, so we can always.
No, but then the person who filed the execution application, despite receiving the notice, he has not come.
He remained
So
absent.
matter ends there. Why should we pass such a lengthy order? Though we have passed the major part of the order, only this much is remaining.
Yes.
No question. We cannot accede to your prayer. This court was inclined to basically accept your thing and directing him.
My lord, because I am party in the case, my lord. So whether order is correct or not, that is before this.
See, the fact remains that you have not approached the executing court with the application for stay. Where it is said that you have been authorized by the others also. They are all separate. You have been made party by name all separately. It is not that you are defending the case on representative capacity.
She is the mother, my lord, and the other two are son, my lord.
It's all right, but then they are made party individually. Yes. They are all grown up, major, isn't it?
They measure, my lord.
Then see, unnecessary. You can simply say that he has not come forward to defend this.
Yes, my lord. Respondent number 2, my lord, is not here.
And he is the person who filed the application. See, and that even this review application, if you go by the statement made in this your application, you will find that review also was filed by the respondent number 2 only. Where is your review application?
Review application was filed by respondent number 1.
It's not enclosed, my lord.
No, it is enclosed. It was filed by respondent number 1.
Review was filed by respondent number 1. And stay of execution is by respondent number 2. But then they were not acting on representative capacity.
No, my lord.
So
this honorable court has taken note of that also by the order dated 24.
Where is the review application? Have you annexed it here?
16, my lord. Page number 16, my lord.
Page number 16. The applicant is only one.
Who had signed?
Chahita Begum.
But then if you see the first title,
yes,
in both the cases it is same. Cost title they have given always like this, but the application is filed by only one.
No, but then we have to go by the cost title or by this thing. And represented by his legal heirs Sympathy Jahida Begum and others. What is meant by that? Who is others?
Others are these
two sons, my lord.
This is their petition they have filed, my lord. They have not given properly.
See, you should. This is for you to raise all those things, because in civil matter, all this thing. In civil cases, all these thing matters.
My lord, order is also there on 24/9/2024 by this honorable court.
Yes.
That only one respondent appearing, and there's 2 and 3.
That is all right. There is no dispute with regard to that. Now, how do we decide who filed this review application?
Review application, my lord. This respondent number only one has filed.
But see the cost title.
Yes,
See the cost title. Go by the cost title. And then if you see this review application and this application for stay of execution, both are same.
Yes, my lord.
There is no difference.
And others, my lord.
But here, my lord, the respondent number 1 is there, and they are saying that respondent number
They have executed this thing. This one of them may have signed the
yes
affidavit.
yes.
And you have never challenged that those locus standi or their locus standi to see file application in the representative capacity.
I have here I have mentioned, your lordship, that paragraph number 8, that respondent number 2 has filed the application in my petition.
That is, you have said, but then where is that reality? In reality, in both the cases, petitioners are same. So how do we distinguish that? How do we say that petitioner in review petition is one person and petitioner in that application stay is another person?
My lord, and he is also there. If he can say that no, all are filed, then let it be considered, because I am not on that point.
See, we are not to go by these things. These are matter. All these are matter of records. Your mayor saying will not do. The record must show it.
In the record, there is no name of this.
Just what was the thing? It's all right. You do not know. These are all mess. You see, you do not take
My
this
lord.
even minimum pain to find out all those things.
No, my lord, when the application
In the original suit,
yes,
there are 3 separate defendants.
yes,
Suit was decreed.
in the original suit only the father was there, and in the application,
Anyway, the decree was against 3 persons.
yes, yes,
3 separate persons.
yes, 3
The
separate
decree was against 3 persons.
3%. I have filed
Yes.
execution against
And
3%.
then review is filed by only 1 person.
1%.
But then on what basis we say?
My lord, the registration is there. I have not filed that one. That I will say, my lord, this is the they have filed, and then as per the registration, only one is available in that cost title also.
Cost title, my lord. It says others, my lord.
Others, so who is others? The name has to
Other,
be,
my lord,
cost
who?
title appears, everybody has to be there.
You just say, what is the last part? Just challenge the maintainability of this revision application and submits that the order impugned is only an interrogatory order and that same cannot be challenged by invoking revisional jurisdiction of this court. Mr. Singh, stop. The learned counsel further contends that the execution proceeding is still pending and the petitioner should have approached the executing court before coming to this court by way of this revision application. He submits that the order dated 29/7/2024 does not suffer from any illegality. And hence, the same requires no interference by this court. Stop. Upon hearing the learned counsel for the parties, it is in paragraph, okay? After upon hearing the learned counsel for the parties and having gone through the materials of the record, it is clear that the this is a title execution case number 1. Yes, it is clear that the title execution case number 1 within bracket H of 2024 is pending before the executive court, pending before the learned executing court, and the petitioner herein has not approached the said court with other any fresh application seeking vacation of the order dated 29/7/2024 on the basis of the on the ground, not on the basis, or by raising, do not say on the ground, by raising the plea of order 21/26. Stop. The order dated 29/7/2024 is not a final order in the execution proceeding. And the petitioner has the option of approaching the same court seeking vacation of the order dated 29/7/2020, or the vacation of the said order, As it appears to this court that the order, that the impugned order is only an interrogatory order, and the petitioner interrogatory order, and probably if there is any repetition of the first line, second line, you just cancel it later, or when you make it, show later. Okay. And the petitioner has the liberty to approach the executing court, this court is not inclined to pass
in this court is not inclined to interfere with the situation at this juncture. Stop. It will be open to the petitioner to approach the executing court. With an appropriate application. Raising the plea of Order 26. What is it? It is open to the petitioner to no, you do not. That's before that's a before the trial court seeking stay of the order dated 29/7/2024, not 29, huh? Order dated 9/7/2029 by raising the grounds by raising the plea of Order 26, Rule 21. Order 21, Rule 26. If so advised. Stop B paragraph. With the above, this revision petition stands disposed of. Instead of wasting your time here, you could have approached that court later. Because
that order was,
that remains still a question whether it's interlocutory or referendum.
as per my understanding, this is where this honorable court can interfere, but still. Or I have to file a application for. Again.
You will approach the court. That will your court has kept that option open to you. It's up to you what you choose. We said that we are not interfering at this stage.
Yes.
Okay. And then it will be open for you. It will be open to you to approach the thing.
My petition is still pending there.
You filed the application already.
Execution proceeding.
No, seeking stay of these things.
Not seeking application they have filed. I have to file for vacating.
That is what.
But my lord, I can, instead of filing the application, I can raise that.
But then what is the problem in drafting? Is it, if it is barred in, is it barred in law?
My lord, then situation will come like this, your lordship, that when the order to, when the application for execution is filed within 2 years, no notice is required. But now when I will file, then again the process will go and again they will.
No, execution has already been filed.
Yes.
So that 2 years will not run now.
My lord, I understand.
That
but
part
the
is
notice,
over.
There was no requirement of serving the notice. They have come. Now we'll file application, then the executing court again it will issue notice. The situation will be.
No, they are already there.
We are already
there. They are already. Is it the case that execution case will not proceed anymore?
I think, my lord, because again notice will go after filing the application. Okay, let me convince the court, trial court. The situation will be different.
Just do one thing. But then how do we may pass some order and then you may decide not to file any application.
Expeditiously dispose of the execution procedure.
Let him file application, appropriate application first, my lord. Without filing application, my lord, how can direction be?
Just before you said in the above terms disposed of, just before that, in the previous paragraph, you say in the event, yes, the petitioner files an application seeking stay of.
Not seeking stay.
Oh, sorry, seeking vacation of the. Yes. Not see that part also. You have to correct. Maybe I have said stay. Okay, we'll correct it accordingly. Yes. There will be some changes here. Probably this court has repeated many things again and again, so it will be deleted. So
file an application.
Just say in the event if any application is filed by the petitioner before the executing court seeking vacation of the
order dated so and so, order dated 9/7/2024, comma, the shall be disposed of at the earliest by the London Executing Court. Yes. Obliged. Then you say with the above. Yes.
Item number 23.
My lord, this item number 28 and 29, this is a criminal appeal. So this may take little time, my lord. So what we were discussing and would like to propose is, my lord, if this matter can be taken on Thursday, so if Thursday doesn't finish, Friday we can finish it continuously, my lord, so that, my lord.
Thursday means next week, you are saying?
Coming week, Thursday, my lord. So that we don't have to remind, my lord, again. The Thursday,
See, coming week, Thursday may be a holiday. See, 10th.
10 is a holiday, okay. Then the 8, 9, 8 and 2.
Very difficult, Mr. Yavin. Okay. She can give you a better idea. See,
okay.
You see, unnecessary listing. If we take up one matter in a day, then it will take the whole day.
My lord, this because if I start now, we hardly have half an hour, and the second hour, second hour.
Right, so we'll do it and we'll have it, and then after 1 week or something, it will be possible after 1 week.
So we'll take from the course master to do convenience of my lord.
Saying that after 2 weeks then.
2 weeks, my lord.
Okay. The request made by Mr. P. Ewan, London Council, the paying for the appellant list this matter after 2 weeks. Next matter also same?
Same, my lord.
You are also there. Next matter also same. Next is what matter? Item? 28. Okay. Both the matters same order. That RLR order, you can make a draft copy and then show it to me and people will